Welcome! Let's now play a game. Supposing that you are Jerry Raymond Mullns, a barrister with Beach in Queensland. It is April 2001. Your client, Miss White, has just been in a serious motor vehicle accident. He is wise, but is left underemployed. He asked Mr. Arrett, he is solicitor, to bring a compensation claim against Suncorp, an insurance company. Mr. Kent asks for Suncorp. And before mediation, the claim relies on affidavit's report based on assumed life expectancy. On 16th of September 2003, 3 days before mediation, Ms. White tells you he has been diagnosed with secondary cancer. He asks that this information to be kept confidential unless the law later requires it to be disclosed. And on 18th September 2003, mediation takes place between Mr. Wright and Suncorp. You attend as Mr. Wright's barrister, together with Mr. Garrett, while Mr. Kane represents Suncorp. The discussions proceed on the basis of affidavit's reports, including the assumed life expectancy figures. Finally, at tribunal stage, after the mediation, Mullns' conduct eventually comes before the legal practice tribunal, is found to have acted improperly in handling the case, and faces disciplinary consequences. For the purpose of this project, the same events are not treated as if they occurred in New South Wales, and UNSW law applies. What would you do if you were given a chance to put yourself in Miss Molly's shoes?
Hi, Miss White.
Hi, Miss Mullns.
Yeah, how are you?
Good, thank you.
Yeah, take a seat.
Yep.
There's something you need to know. I've recently been diagnosed as secondary cancer, but the doctors still cannot find the reason of primary cancer.
Well, we will probably need to, tell Suncorp. If we do, they may postpone the mediation because they need to consider how this affects their claim.
I want to get this settled as soon as possible. If we delay, Suncorp may jump in. But somehow I heard, I don't want that to happen, unless the law requires it.
Okay, wait a second. Let me check with a senior. Hi, Jane. Do we have to disclose something that might work against our client interests? At trial.
It depends on circumstances, but generally no, you are not required to.
Okay, got it.
Now it's time for you to choose.
I heard January no, but nothing else detected.
Good. Then let's go ahead as planned. I'll see you at the mediation tomorrow.
Okay, hi Kent. We put future economic loss at this figure. And it's based on the medical report. The future care claim is also reasonable, and the economic loss is based on the evidence reports.
We have a deal then.
Okay.
2,000 years later.
All rise. The tribunal hereby find the respondent's behavior amount to professional misconduct and impose a public reprimand and a 20,000 penalty.
Now, enough with the dramatization. Let's start the analytical part.
What exactly was the ethical dilemma here? Was it whether Mullns should disclose the cancer fact to Suncorp against Mr. Wright's wishes?
Not quite. The real ethical issue was Mullns' continued reliance on the misleading evidence report in pursuing the injury claim. According to barrister rules, once he realized the misleading nature of the report, he was required to take all steps to correct the claim.
I see. So that's where the dilemma comes in. If Mullns told Suncorp that it should reassess Mr. Wright's health condition, the settlement could be delayed and Mr. Wright might receive less compensation.
Right. Shall we now break down his action to identify where his behavior went wrong? Use REST for component model?
Sure. The model starts with moral sensitivity. It means recognizing when a situation involves an ethical issue and coming up with possible actions. I don't think Mullins completely failed at this stage, given that he immediately noticed a potential ethical problem when Mr. White told him about the cancer diagnosis. That's why he initially suggested to disclose the information. The failure lay in the fact that he did not consider that correcting the misleading claim could also be an option.
Let's move on to the next component, moral judgment. It is deciding what the right course of action is. Mullins failed at this stage because he asked the wrong question. As mentioned earlier, he mistakenly focused on the disclosure issue, thereby failing to determine if it was morally acceptable to continue relying on the misleading evidence report to support the claim against Suncorp.
He also failed to make the third component, moral motivation. This is about prioritizing ethical duties over other interests. Mullins failed because he prioritized Ms. White's financial interest over his duty of candor. He treated settlement like a commercial negotiation, where parties are expected to be cautious about relying on the information provided by the other side.
The fourth component is moral character. It asks whether Mullins had the character traits and skills required to do the moral action. It's hard to tell if he had failed at this stage, because the facts do not explain that why he did not correct the misleading claim. It may be attributed to his lack of courage and ability to act, or instead his failure at the stage to determine what morally right action was.
In terms of moral sensitivity, Mullins' experience as a barrister enabled him to recognize that this situation involved an ethical issue.
On the other hand, selective attention and ethical failing acted as disablers. Once Mullins identified disclosure of the cancer diagnosis as a possible solution, he continued to focus on the issue while overlooking other possible actions. His description of the compromise as commercial further minimized the ethical significance of his continued reliance on the evidence report. In terms of moral judgment, Mullins' overconfidence hindered his reasoning. He thought he had correctly identified the ethical issue and did not further verify his understanding by referring to the barrister rules.
In his augmented model, Breakey helpfully added that cognitive bias can also affect moral judgment. The tangible and abstract bias may have caused Mullins to focus on the matter of disclosure, because Mr. White directly and vividly asked him to keep the cancer diagnosis confidential unless required by law. In contrast, Suncorp's reliance on the misleading evidence report was more abstract and less immediate, so it abstracted less attention in his moral judgment. This biased focus was then reinforced by confirmation bias. It led Mullins to seek information that supported it instead of questioning whether he had identified the real ethical issue. This also explains why consulting senior counsel did not become an organizational enabler as suggested in Breakey's model. Because of confirmation bias, Mullins only sought advice on disclosure issue, but the advice never redirected him to the real ethical concerns. This also highlights another disabler: the lack of a structured process to check whether the ethical issue had been correctly identified.
At the professional level, genuine regulatory ambiguity about silent misleading in negotiation helps explain why he felt able to read the rules as he did. The uninspired one-month period given by Section 45(3) of Motor Accident Insurance Act 1994 Queensland may have looked like a temporary window. Because only about 2 weeks had passed, Mullins could have reasoned that immediate notification was not yet required. Combined with a narrow interpretation of Rule 51 of New South Wales Barristers' Rules, silence at mediation appeared to be a safe harbor. However, the ambiguity explains without excusing because he made positive representations rather than staying silent. Rule 15(1) doesn't protect this conduct. It applies only where a barrister merely fails to correct an error in a statement made by the opponent. Mullns instead adopted and relied on the reports. His conduct therefore falls within Rule 49, while Rule 50 required a proactive action.
You inspired me. What if, before starting moral judgment, Mullins had already preferred to keep the cancer facts confidential? This preference, together with legislative ambiguity, may have allowed the rationalization to distort his understanding of ethical obligations by narrowing the possible courses of action to only two: remaining silent or lying. As the latter was obviously unacceptable, this left the remaining silence. In another word, continue to rely on the misleading Evidex report as the only acceptable option.
For moral motivation, rationalization is a significant individual disabler. It allows Mullins to justify prioritizing Mr. White's interest over his duty of candor, even if this conflicted with his professional obligation.
The standard concept of lawyering was a systemic disabler. Driven by the loyalty to his clients, Mullins followed Mr. White's wish to settle the claim quickly and secure the highest possible compensation.
On the other hand, Rules 35 and 42 act as systemic enablers. Together, they require Mullins to advance Mr. White's interest only by proper and lawful means while exercising his own independent judgment. They emphasize that, as an officer of the court, his professional obligations should take priority over Mr. White's personal interests.
Lastly, for moral character, Mullins' sympathy has acted as a potential disabler. Mr. White has not only become quadriplegic, but also has been diagnosed with cancer. So it was understandable that he wished to obtain as much compensation as possible. As a result, Mullins might find it emotionally difficult to do what was morally right, if that meant reducing Mr. White's compensation.
Insufficient courage could also be an individual disabler, which affected Mullins' conduct in two ways. First, he lacked the courage to choose available alternatives, such as disclosing the cancer facts, seeking an adjournment, or stopping reliance on the reports. Second, after the client resisted disclosure, he did not continue persuading the client to take the ethical course. Instead, he accepted the client's preference and proceeded with the mediation. His failure was therefore not a lack of options, but a lack of courage to pursue and maintain them.
So one way to address cognitive biases that affect Mullins' moral sensitivity is to acknowledge their existence and understand how they work. For example, had he realized that relative attention might narrow his focus, he could have deliberately considered other possible courses of action.
We could also introduce a checking system, that is, whenever a lawyer receives new material information relevant to a case or settlement, they must check whether it affects any statements previously made to the other party before continuing with the matter.
From a broader perspective, Breakey's augmented model suggests that clients, as demanders of ethical behavior, may also influence moral components. Therefore, one approach is to make clients fully aware of the consequences of their lawyers acting unethically. In this case, it would be putting Mr. White's settlements at significant risk. This may encourage Mullins to act ethically.
Let's now discuss moral judgment. First, Mullins need to become familiar with the barrister rules and understand how to correctly apply them when making ethical decisions. This will at least help him focus on the correct ethical issue.
In addition, similar to the approach suggested for moral sensitivity, Mullins also needed to recognize and understand the cognitive biases that could affect his moral judgment and reasoning.
While Mullins did seek advice from a senior counsel, it would have been more helpful had he sought advice from multiple sources instead. Such social deliberation may bring various perspectives together, thereby encouraging deeper analytical reasoning in his moral judgment. However, since barristers usually work in a relevant
the independent environment, this approach may be more effective for those who have already developed moral support networks during their practice. For those who have not, seeking guidance from the New South Wales Bar Association would be another option.
And doing so may also provide institutional support for Mullns to reform his moral motivation. That is, by recognizing that his duty as an officer of the court must take priority where pursuing the client's interests conflict with his professional obligations.
Yes, he then needs to establish clear ethical boundaries that he will never cross under any circumstances to prevent his reformed moral motive from being weakened.
For moral character, Mullns would need to strengthen his professional virtue. One way of doing so is by participating in ethical training programs such as continuing professional development, which provide ongoing opportunities to reflect on professional responsibilities and ethical issues. This may help him develop the character traits needed to act on his ethical obligations, even in emotionally difficult situations.
Mullns would also need to develop his implementation skills to successfully carry out the moral action. Assuming that he has now decided to persuade Mr. White to correct the misleading claim, the GVV method suggests that he should first clearly define his personal and professional purpose and prepare a script before speaking with Mr. White, which would help him to act upon the professional virtues he has developed.
One last point. Moral review may also help Mullns rebuild his ethical practice. It is a moral process adopted by Breakey that refers to reflection on one's actions after the event. It is useful here because, through proper reflection on his failure, Mullns may learn from the experience and make better ethical decisions in the future. To do this effectively, he should also avoid working to exhaustion, as the process requires sufficient cognitive capacity.
Now let's rewind and play it again.
Flashback.
My doctors have found secondary cancer. I want to get this claim finalized, but I don't want this diagnosis disclosed until the law requires it.
Now it's time for you to choose.
We don't have to disclose the diagnosis itself, but we cannot rely on an assumption that we know it could mislead someone.
But if we move quickly, we must still settle this before someone finds out about this diagnosis.
I fully understand it, Mr. White, and I'm so sorry you are going through this. I have the duty to act in your best interest, and I won't disclose the diagnosis itself without your authority unless the law requires it.
Oh, that's good to know.
But we also need to think about what happens later if Suncor find out. The settlement could be challenged, and that could put your whole claim at risk.
Yeah, I suppose that's possible. Insurance companies are pretty good at finding these things.
Well, if we tell Suncor that the assumptions in the evidence report need to be reviewed because of the change in your medical condition, we can keep the claim on a proper basis. It may reduce the compensation, but it avoids much bigger risk later.
Then we better call Suncor now.
Yeah, let me assure you again. We won't disclose anything beyond what we are authorized or legally required to disclose, but we will remove the misleading basis and tell the Suncor that the assumption need to be reviewed again.
Agreed.
Thank you.
Thank you.
See you.